when we talked about what the theme of the meeting was, getting to gold without tarnish, I said that there were some things that were important for us. There's obviously been two things that we've covered very well, looking after our possessions and looking after our activities, a very moving performance, I might add. Not performance, explanation of opportunity. And now I'd like to point out something that is critical to everyone. Many of us, it's one of those things that you say, yeah, I'm going to. And I have to tell you, when your time's up, your time's up. I hate to be morbid about it. I'm not trying to be at all. It's just always nice to be better prepared. And actually, I'm quite excited to have a notary public here in Vancouver who has worked in this area extensively, who comes here with no axe to grind or profit to make. She simply wishes to inform and advise. So that's a wonderful thing to do. She'll give us an overview of important aspects of planning for your retirement, of doing the things you haven't yet done in your retirement, and planning for the future, as well as some of the obstacles and barriers you might encounter along the way that aren't pleasant or could show you to have some difficulty. Ladies and gentlemen, I introduce Hilde Deprez to discuss wills, medical representation, powers of attorney, and opportunities on elder abuse, the potential there. It's not just for you. You have your parents, you have others. Thank you. Hilde? Hilde? There you are. Here you go.
Thank you. Thank you. Good afternoon, everybody. It's so very nice to be here. I've actually been asked years and years ago to also be presenting. A little bit closer. To also be presenting for this lovely group. So it's a true pleasure for me to be here today and to talk to you about a topic that is very dear to my heart, because I deal with this every day, and I also see what happens when people don't have their planning documents in place. But I really want to talk to you about this because it's relevant and important to each and every one of you sitting in this room, because we will all be impacted by this, one way or another. So the heading of my presentation is around estate and personal planning, and you can see there that I've highlighted the word empowerment, because this is the main goal of this brief presentation that I have for you. As teachers, you know that knowledge is power, and power may sound like a bad word, but it is how you encourage, how you give people that oomph, to do what they need to do. So to take charge, to plan, and to protect. And the protection is not just about your loved ones, but the protection is also about yourself. So I only have 50 minutes, and I think now it's even less than 50 minutes. So you will all appreciate that it is totally not possible to basically discuss these very important topics in just 45 minutes time. This is therefore not meant to be an educational tutorial. And since you are all teachers and very organized people, I am not going to ask for a raise of hands, but I would assume that the vast majority in this room has already put a lot of these papers in place. So my main focus, while I have some time with you here, is to maybe bring things forward that you may not know or may not just have looked at it from that perspective. So just sort of like tease you a little bit and make you think about it and do a little bit more of research where is needed. And so you can see here the 4 topics that we want to talk about: powers of attorney, healthcare, wills, and then some cautionary tale. I want to start most definitely not with the will. It's intentional, because my main focus as we sit here all together is to first focus on what happens while we are still alive. I think we should first take care of that before we start taking care about what will happen when we're not, right? And powers of attorney are my top priority here. The reason why a power of attorney is a top priority is because there is no default. And we will elaborate on that in a little bit. You may or may not know that there are 4 different types of powers of attorney. We have a general power of attorney, which speaks for itself. It means you say, the person that I trust is allowed to do any and all things that I can do, right? Second one would be a specific or a limited power of attorney, which would basically mean that you say, while I am the snowbird traveling down south for 2 months, I want someone to be able to handle some or all of my affairs, but only during those 2 months. Important to note, and a lot of people don't know this, is that a general and a specific power of attorney are only valid while you are capable, which is very different, and here it comes, to number 3, which is the enduring power of attorney. The enduring power of attorney is the only power of attorney that is valid while you are capable and will continue to be valid if you become incapacitated. So a lot of people coming to see me are quite confused what enduring power of attorney means, but this is what it means. It means that you have created a legal document where you give someone an unconditional mandate of trust to basically deal with your financial and legal, because this is financial and legal only, affairs. From the moment you sign the document, it will endure, it will continue to be valid, no matter what happens to you, capable or not capable. All right? The last one that you see on the screen here is springing powers. The springing power of attorney is a power of attorney that hardly any legal professional likes. We really don't want it. Yet, the average client coming to see us in practice is asking for the springing powers. What is it? It is when the client comes in and says, Hilde, I want to make a power of attorney for when things are not going to be okay with me, but I only want it to kick in when 2 doctors give a medical report saying I'm no longer competent, right? So the springing power, you basically say, my power will only spring into effect sometime in the future when certain conditions have been fulfilled. Where I can appreciate that people coming from a cautionary point of view say, I would only want this to be effective when certain things happen. The reality is, this is a very non-practical, realistic document. Think about it. First of all, most of us, as we age, will be grateful to have some help from time to time with some aspects of our financial and legal planning. Maybe you are recovering from surgery. You are completely competent, but you have mobility issues, or you have macular degeneration. It's difficult for you to do signing or do the computer, or you can have any other reason why a certain task is a bit challenging, but you are fully competent. And then you would not have someone who can help you, right? Second reason is most medical people take it very, very, very seriously before they're going to say that someone is no longer competent. This is a very high threshold. People don't just easily put on paper, you know, this person is no longer competent, because it has far-reaching consequences. It's difficult to find 2 doctors. A lot of people now don't even have a doctor. And so if You do this, by the time that a need presents itself and you would actually have a document that can kick in, we're months later. And in the meantime, you were not helped, right? So just wanted to position that. So these are the powers of attorney. Power of attorney is extremely, extremely important for everybody to help, no matter what age you have, because the main thing is there is no default. You could be married for 40 years. You can have joint home, joint bank accounts, but that does not mean that your spouse of 40 years has any legal access to your assets. If you own the house jointly and one of you suffers a stroke or has a cognitive decline, it takes both people on title to sell the place. It takes both people on title to be approved for a mortgage, to do renos, to accommodate your care needs. It's not just one who can say, I'll just sign for him or for her because I know that's what he or her would want. It doesn't work that way. Your RSP is your RSP. It could name your spouse as a beneficiary, but that only takes effect when you're gone. As long as you're alive, that is your account. If you suffer a stroke, your spouse cannot go to the TD Bank and just withdraw money from that RSP. That doesn't work. Same with tax-free savings account, same with income tax filings, same with car insurance. Cars are typically in one name, not in both names, and on we go. So I just want to really empower you and say, even if you are set up as a couple in complete financial togetherness, do not think that you will be able to cover each other when one of you is not doing so well. The legal, financial, and fiscal world does not think that way, right? So doing a power of attorney can save you all of this headache. If you don't have a document and something does happen to you, which happens all the time, then basically the only recourse is to do an application to court to be appointed as someone's comity. It's a lengthy and costly process, and you will be pushed 10 months to a year out from the date that the need presents itself. And this would be assuming somebody steps forward and actually wants to assume that role on your behalf. I also have clients who don't have anybody stepping forward. And you may think, well, that would not happen to me, but it is far more common than people think. My typical client is someone who in the meantime has long been widowed or was single, is 94 years old, had no children, or the children live in different parts of the world or of the country, and you end up just with no one, right? And then we have the public guardian and trustee stepping in. So this just to say, power of attorney should be on the top of your list. Few things about appointing a power of attorney, right? The legal requirements for a power of attorney for the person appointed is that the person has to be at least 19 years old, and the person cannot be in a position of employment or providing care to you, except if it is your spouse or a child. And you may think, well, that sort of speaks for itself, but it's not uncommon for me to have clients who completely depend, the only social contact they have is their care provider. And they often start to trust that person completely. So for many clients, when I tell them they don't have that option, it is a difficult proposition, but it's not possible. The next thing that I want to touch on is most clients coming in will say to me, I'll appoint my daughter because she lives in Vancouver, and my son is in Comox, and my other son is in Toronto. Just please think about that. Even though I can totally appreciate why you appointed a person that is geographically closer to you, you need to also consider, of course, the trust component. You need to consider who is best suited for this, right? Who has the best ability to deal with this. But then also, what is going to be the interplay of the siblings when I pick one over the others, right? And the others don't know that your sole decision-making factor was, the one that lives the closest. They don't know that. They will think, oh, this is the favorite one. Or they think only he or she can do it. Why not me? So be considerate towards the impact all these decisions will have on your children and how they view each other and how they view you and how you made that decision. It's typically good advice to have more than one person. Just the general principle, don't put all your eggs in one basket because something can happen to that person as well. If you name more than one person, then the question is, do you point them in a high priority ranking, or are you going to put them in a side-by-side equal trust, and basically whoever is around and has the time to do it will do it? Whatever it is, the document has to clearly stipulate this, obviously, right? The other thing, briefly to touch on, is the residency of your appointed attorney, which of course relates to the geographical location and the practical aspects around that. But also, if the appointed person lives outside of Canada, which again, within my client base is not unusual, especially with the US, you should really stop and think very, very carefully whether you will actually appoint a non-Canadian resident to be an attorney, because it can have significant financial consequences. If you have an investment portfolio, your investment portfolio manager may not be able to take instructions by law and by protocol from a non-resident. You should be aware of taxation implications. And that would be the same, by the way, when we talk about an executor. Because the idea here is that if you appoint someone out of the country, you actually have you've moved where the center of the power is out of the country, all the executive decisions being made outside of the country. So therefore, if it is, for instance, in the US, there is a duty to report to the IRS. So just be careful about that and just double check with your tax and financial advisors what would be the best route of action. And then a last cautionary tale here is around blended families. What I want to say here is that when I meet clients and it's a second or a third marriage or relationship, spousal relationship, and each has children, adult children from a previous relationship, you want to really discuss this very clearly, that since we don't know who will go first or last, since we don't know who will be not well and will be healthier in the long run, you can basically, by depending on who you appointed to be the executors, but also the power of attorney people within that family structure, all the power can have tilted to one side. Let's say the house is in joint names, and we've got John and Susie, and they have adult children from different marriages. And John, sorry to do this, right? And John suffers a stroke. And basically, Susie now has the power of attorney over that. She can make any and all decisions regarding the money, using all of his pension first to run the household and save her pension, so that when she dies, she has built up more money in the bank, than to the person who was not well. And this is just a simplified example, but just to say, when I have blended family structures, I prefer that there is a representative appointed from each, side, so that, it's not Russian roulette as to who will be the ultimate power player in this household. All right, moving on. A few things about the power of attorney in closing, and then we'll talk about health documents. A few things here, and I may be not going to touch on everything, but I want to say Did you know that if your document is not specifically stating that your attorney is allowed to compensation, they are not allowed to compensation? I'm just saying that, right? Did you know that if your document is not specifically addressing that your attorney is allowed to make gifts, charitable donations, or loans, then they are not in a position to do so. So anytime you are a client and you are paying for your grandchildren's math tutors or their after-school activities or any of that sort, if tomorrow you were to become unwell, this would all cease and stop, unless your document specifically allows for it. Just want to clarify, the rationale for this is when someone acts as your power of attorney, they have to act in your best interest, and it is your money, and the money is to be used for your purposes, not for third parties. So that's the reason why, right? When you're a single parent and you have 23-year-old and a 28-year-old still living in your household who depend largely, if not fully, on your financial support and running of the house, you will want to make sure that your document allows for that. Okay. Yep, good. Just gonna move on for the benefit of time, how we're doing for time. Yeah. So, yeah, the health and the care legal documents, I on purpose did not put any specific name here because it's a bit of a labyrinth out there and people are using all these names not always in the accurate way. So I'm gonna start by hopefully clarifying a little bit for your benefit. So how did we get to this point? With that, I just wanted to go back just a little bit and say, for the longest time, the only thing we had in BC was living wills, right? And living wills were largely this unilateral document that somebody writes one day at their desk and says, if X, Y, and Z happens to me and it all looks pretty bad, then I don't want you to do anything, heroic to keep me alive. And we had this forever. And, since roughly 2011, this is kind of dead in the water. Right? We don't have living wills, and if you have one, it's worth nothing. A living will needed to be revisited, and we needed to step away from it because basically, to the point, you were throwing the ball to the healthcare authorities and the health providers and basically saying, you decide when it looks dire and you decide when, it should be heroic. And it puts them in that position of potential lawsuits for negligence, family members saying should have, could have, didn't know about it. So that doesn't work in today's reality of the world. So what do we have now? We now have, since 2011, representation agreement. I'm sure you're all familiar with it. And it's just in the word right there, the big difference with living will, because it says it's an agreement you enter into with your representative, right? The person you've picked, one or more, to basically, again, be your voice. The difference here with the power of attorney is not only power of attorney is financial and legal, this is health and care, obviously. This is also both for when you are alive, but the difference is, remember, power of attorney takes effect immediately, meaning you give it to the wrong person, they can basically go to the bank and take some money out of your account. When it comes to representation agreement, it isn't, because the law is very clear and says, only when the patient cannot provide consent or refusal themselves do we default to the representation agreement. So the dentist, the physio, the surgeon, your GP always has to deal with the patient. If you've named your daughter as the representative, she cannot just walk into your GP's office and say, I want to know what my mom's file looks like. It doesn't work. As long as mom is competent, mom can provide consent and refusal, no one else enters the arena. We have two types of representation agreements. We have the Section 7 and we have the Section 9. Section 9 is the one that is normally in place. It's what we call the document with enhanced powers. This is when the person making the decision, drafting the representation agreement, is deemed to have all the capacity that is needed so they can make a decision as to what this document is about the powers and the duties of the representative. In other words, this is someone that understands fully all the consequences of this document. Therefore, this means a Section 9 representation agreement grants someone the power to make life-ending decisions, should that be needed, right? It goes all the way. The Section 7 representation agreement is because the lawmaker recognizes that not necessarily everybody can operate at that same level of understanding. Maybe because of a special needs situation, maybe because of an illness, maybe because of an addiction, maybe because of who knows what. You just cannot really meet that higher bar of capacity test. But you can totally express yourself and say, I would like Susie to go with me to my meetings. I trust Susie to help me with X, Y, and Z. So a Section 7 representation agreement does not allow life-ending decisions. Right? So then we have the advance directive. There's a lot of confusion, at least that's what I seem to see in practice around advance directives and what it really is, right? An advance directive came in effect by the legislator because they recognize that not everybody has a representative. Again, just like with the power of attorney, it's not unusual for me to meet a client who does not have someone to appoint. Because if we're blessed with a long life, one of the side effects of living a long life is that many people we once upon a time had around us and were our friends, circle of friends, colleagues, and so on, they're no longer there, or they are no longer able to help us, right? So it's just what happens over time. An advance directive is very different from a representation agreement, and it's right in the word if you think about it. It says that it's a directive that you advance, right? So it's easy to kind of like remember it that way, because what you're doing is you are sitting at your desk and you are writing very clear, specific instructions to the health care providers directly. Because remember, you don't have an advocate, you don't have a representative. You're directing them, you advance forward your directions and say, if X happens to me, then I want Y or I don't want Y. So an advance directive is very different from a representation agreement because you don't have a spokesperson. You're speaking directly to the not yet met healthcare provider, and it can only deal with medical. It cannot deal with care and personal well-being, right? So a representation agreement is really about medical care, or as I call it, living arrangements, like, you know, where do you live, how do you live, and personal well-being, diets, exercise, all these things. An advance directive is purely to the medical people. It's not about where you should live, should you go into a care home. It's not about, you know, diets and any of that. So therefore, it is limited in its scope, right? So therefore, the general approach is that if you have someone that you can name as your representative, this is always better than having to resort to an advance directive. People using an advance directive are, like I said, usually people who are of higher age and have difficulty finding a representative, and or people who already have a diagnosis and know what the journey of that disease will look like, and they have very strong opinions about it, and or people who have a genetic predisposition on something, and they also want to be very clear in that regard. The other word used in this context often is express wishes. So express wishes are just exactly what it says. It's just you're expressing your values, your beliefs. You don't have to do that. When you make a representation agreement, you don't have to say, I don't want you to do this, but I want you to do that. You don't have to clarify that. Just like in a power of attorney, you don't have to say, don't forget to pay my house insurance and don't forget to pay my income taxes. Like, it's deemed that the person you've appointed will be capable to handle that mandate and will do it to your best interest. But having said that, a lot of clients like to express their wishes. Not because they don't trust the person they've appointed, of course not, but because they want to lift the ethical burden from that person and say, I wouldn't want him to worry about it. Or because you want him to have a big, stronger voice to the healthcare providers to say, no, I'm not saying that because I'm in shock or I'm a bit stressed or overwhelmed by what is going on with my parent. I'm saying this because my parent has told me this 10 years ago, that they wouldn't want this, right? So expressing wishes can be quite beneficial, but it is not mandatory. It's like a supporting document that you attach to your representation agreement. So, like with the power of attorney, the question is, if you've planned, you've made these documents, right? If you didn't plan, what happens, right? With the power of attorney, we said, oh, doom comes because there is no default system. Ironically, when it comes to our health and our care, there is a default system. It is called the temporary substitute decision maker. The law basically has it very clearly embedded. If there is a crisis with you and you cannot provide consent or refusal to a medical intervention, they will go to your spouse. If there is no spouse, to your children. If there's no children, to your parent. If there's no parent, to your siblings, and so on and so on. So there is a priority order that is to be followed. And then you could say, well, why do I need a representation agreement if there is this substitute decision making? Well, when it comes to the spouse, we're fine because we assume you only have one spouse. There can be no competition, or there should be no competition. But you could have two spouses, and we laugh about it, but plenty of my clients have multiple spouses. They have the spouse that they once were married to, are separated from, but not yet divorced, and in the meantime, they are in a spousal relationship with someone else. So technically, they have two spouses. Just, to spice up the afternoon a little bit. So back to the substitute decision-making part, to say that when it comes to spouses, we typically only have one. We should not have too many problems. But then if there is no spouse, or the spouse is also incapacitated, and now we're defaulting to the children, the moment you have more than one child is where we have an issue, right? Because the medical system puts all of your children on equal footing, and rightfully so. But that means that whatever needs to be done now, the social worker and the team needs to get all 5 kids on board and needs to get from all 5 a yay or a nay. And that can be quite challenging. This is the reason why most care home facilities, whether it's senior independent living or not, they will want people to come in with representation agreements because they want to have one straight line of command. They don't want to have to consult with 3 or 5 different people. So I just wanted to illustrate there how a representation agreement, serves more than one benefit, right? And again, if there is no substitute decision maker, or it is a long-term situation, then basically we go back to committeeship for the person or the public guardian, right? Who to appoint as your representative, pretty much the same idea like with the power of attorney, needs to be 19 years old at least, cannot be someone who's employed by you and a care provider, and the same considerations around one or more as we did, so I'll just not talk too much about that. Do want to point out this. If you make a Section 9 representation agreement, which is what you would be making, which is the document saying, if I can't provide consent or refusal, I appoint such and so to do it for me, then they would be able to do any and all things regarding your health, your care, living arrangements, your well-being, safe and except two things. I want to point it out because people don't necessarily think of it that way. The do not resuscitate order or no CPR and medical assistance in dying, as you will appreciate. Only you can do this. These two documents have in common that they are not a legal document, they are a medical order. And it requires you to engage with your physician to do this. Does that make sense? Right? Yep.
It makes sense, except what if you haven't done all the paperwork and you are in a constant state of a coma? Who does make that decision whether they pull the plug, so to speak?
Yeah, it's a very good question. The question about life support, right? And pulling the plug, quote unquote, which is what people say all the time, which is not the equivalent of do not resuscitate, right? Pulling the plug means that you are already in a supervised medical situation, right? And there is already a full diagnosis and everything is already, there. And they do what they can to save or to, make you better. And then at some point they realize this is a point of stagnation and it's not, right? That is very different than you going about your business and you go to Safeway and you collapse there and someone calls the ambulance and you've got in your breast pocket a little thing that says, do not resuscitate. Because a do not resuscitate is a document that someone engages in while they are fine with their medical, with their doctor, and basically say, I've already had several strokes, let's say, and I'm now 91 years old. The next stroke is going to do me in, and I'm going to be a vegetable, and I wouldn't want that. So I now decided that I do not want any resuscitation, so even ambulance people step away from me. Don't even try to save me. If I may put it like this, black and white, does that help a little bit, right? Yeah, so DNR is not the same as pulling life support, right? Yeah. No, you're very welcome. One thing in closing on that is to consider the interplay of your attorney and your representative, which a lot of people don't do. And, the law in BC, power of attorney and representation agreement, two different documents. Money, body, mind, and soul, right? You can name the same person to fulfill both mandates, but you can also name different people, right? It's very common that a client will appoint this person for this. They will say, my son is very good with money, I'll do that, and my daughter is a nurse, so I want her to be the representative, right? You need to realize that pretty much all decisions regarding your health and your care cost money. So if you have not addressed this very well in your document, and each time your daughter says, I think mom would benefit from this, and he goes, I don't think so. Like, I don't think we're gonna pay money for that. So if he's very good with money, so good to the point that he's actually not spending any, and your daughter kind of thinks that you deserve X, Y, and Z, it can lead to huge conflict, constant conflict. But it also can mean, more importantly, that the person who is to be your nurturing advocate cannot do any nurturing because they have no money to do it. Does that make sense? Yes?
Can you put in the power of attorney what type of care home you'd like to go to? And is that an express wishes document attached so that you're getting the kind of care that you want?
Yeah, it's a very good question. First of all, it would definitely not be in the power of attorney because the power of attorney is about money, right? It would be in the representation agreement, which is body, mind, and soul, if I may put it this way, right? You would not necessarily put it in the body of the representation agreement, but by way of an expressed wish, because it is just that. You may not control where you're going to end up. Unless it's private paid care, and then even, but you know, it will depend on what your needs will be, what level of need you will need, where you're going to be, where the hospital sets you first, and then you go from there. So it's not, I mean, you can say what ideally you would want, but it's not legally enforceable.
But it's important to put it in a document. My next door neighbor was put into Evergreen in a 4-room house, 4-room room, you know, 4 people. And she was very wealthy, and her son kept the money. So this is very important that there be some documentation as to where you want to end up.
But to that point, and I mean, we can't elaborate because I don't have a lot of time, but to that point, when you make these documents, whether it's a power of attorney, whether it is a representation agreement, whether it is a will, you appoint an attorney, a representative, and an executor. You appoint these people that you trust to make the right decision. If your son is doing not his fiduciary duty, right, you having said, I want this and I want that, who's going to control that? You've basically placed your trust with the wrong person. That is the truth, you know. See you later, yes. But it speaks to how important this is, right? It speaks to how important this is. And I will say, in closing on the health thing, one more thing. A lot of people come in at first and they have a lot of opinions and a lot of thoughts around medical interventions, and I wouldn't want that, and I wouldn't want that, and I wouldn't want to live like this and that. And I appreciate all of this, but I can tell you that in reality, at least in my practice, maybe it's just me, maybe this is not, we can't generalize, but pretty much all the issues I see are around care and living arrangements, right? People spend a lot of time thinking, oh, I wouldn't want this. But, you know, any medical intervention, your representative, your children, your spouse, they don't make these decisions in a vacuum. There's a medical team, there is social workers, there's, you know, the health authority assessing. There's a lot of people involved to guide you as to what the reality of the situation is. When it comes to care, it's not like that. It's not. You will have a daughter saying, oh, you know, I don't know, mom doesn't really eat much anymore. She just barely does her peanut butter sandwich, and that's all she does. And the son in Toronto says, well, I talk to her every other day, and she sounds fine on the phone. There's nothing wrong with her. And so off they go on different paths as to what would be best for mom and what mom needs. And care is a big, big thing, because here we go again. It's got a big ticket item. The money, which you don't have when it comes to medical interventions, right? Last document, the last will. I think that's the document that all of you are most familiar with, and people will say to me often, why do I need a will? I've got everything joined. I've got my spouse named on all my assets, so I don't need it. I would like to say to everybody, please, please, please have a will. Everybody needs to have a will. The first reason is because, and it didn't really put it in the priority ranking there, but I would say immediate action is required. The moment we pass away, it's not, we may think this is going to be a long silence around us, but it isn't. If you pass away in a hospital, your body needs to be moved. You pass away at home, your body needs to be moved. I'm so sorry to speak this way, but the very first thing that happens when someone passes away is an executive decision needs to be made as to where does the body go to and what will happen to the body. And that is an executive decision that is made if there is an executor. Here you go, easy does it. The first question everybody will ask, is there a will? If you have to say, no, there is no will, you have a whole bunch of walls go up at a very difficult time, right? So it's not about your money first, it's first about your body, right? No, I mean, then it's about clarity and certainty, right? We should know who is who and what is what. It's who will be your executor, who will be your beneficiaries, and how do you view that you're going to distribute things, right? It's your choice. I mean, think about it, how lucky you are here in Canada that you have a choice. It's not an absolute choice, and the recent court cases that have been publicized in the Vancouver Sun and so on make that very clear. You can't just do whatever you want, in a full absolute sense. But think about it, as you may or may not know, the vast majority of the other jurisdictions in the world, you can't do what you want. All of Europe, all of South America, most of Asia, it's all set in the law as to who is going to inherit what. Pretty much what our intestacy rules say, that is the law. Here we have the freedom. Use it, right? You can do good. You can say, I want to include my grandchildren, not in second order, but at first order. You can do charitable gifting. You can do many, many, many things. So, just want to say, take advantage of a right that we have. Appointing your executor, I'm not going to say too much about that because of the sake of time. How are we doing? Time-wise? Moving along? Okay. I think, you really want to make sure that your executor is capable for the job. Oftentimes, you may consider even appointing a special person for some special aspects of your life. If you're a collector of something and your children do not appreciate that collection or have no clue what to do with it, you may want to appoint someone that does to basically deal with that aspect of your life. That could be train collection, like Old English train collection, could be anything. Anything. You want to also consider, the ability for your executor to manage such a complex situation. To me, an executor is a manager. It is a person that basically steps into your shoes right after you're gone. Right away, as we just said, needs to make executive decisions. Where does the body get released to? Which funeral home? What service? When? What? How? All of this. What to do with your belongings? Everything is an executive decision, separate and apart from what the will says, strictly speaking. So you want someone that can do that, that can bring something from A to B to C, who's a good communicator as well. If your executor is not a good communicator and leaves everybody waiting and thinking, I don't know what's going on, it creates distrust, and it's not a good thing. So think about that. Compensation. Lots of people seem to think that when they're going to be the executor, they're going to kind of get the 649 come their way, and they're going to get a large percentage of the estate. I just want to sort of say this is not necessarily the case. It's not because you're the executor, you're automatically deemed to be entitled to a certain percentage, because these percentages are not representative of what the value of your estate is, the complexity of your estate, how many beneficiaries are you accountable to. You can't compare two estates. They're not going to be the same. And one will be easy peasy, smooth sailing, and the next one is going to be, wow, this is quite something. Depends also on how organized the will maker is. Some people leave very nice binders, it's all there, and other people, it's like a needle in a haystack. It's going to be interesting moving forward where people now have everything locked up in their cell phone and they have no paper. So Yeah, just want to point quickly this out. Not everything you have is part of your estate. Like people making a will think whatever the will is this powerful document that's going to control all of my assets. It's not true. Jointly, these three that you see there are not part of your estate because joint assets go by right of survivorship, designated beneficiaries get paid out, and legal entities have their own little magic. One more thing maybe on this and then I'll close. The difference between a specific gift and a residual gift, I just want to make that very clear to you all. If you make a will and you say, I'm going to give $10,000 to Joanne, then basically Joanne does not receive full accounting. She will not need to know how much money you had, what the executor did. She just gets her bank draft of $10,000 and that's it. If you say Joanne is going to receive a certain share of my estate or a certain percentage of my estate, then the executor has a duty to pass full accounting to that person, obviously. That makes sense, I think. But I just wanted to make that very clear because when I talk with my clients, that often makes a huge difference as to how they are going to recognize someone. Right? And then, of course, the big pitfall is that your estate may look very different by the time you die than when you make the will. So you got to be very careful for that. Contesting, big business, huge thing. Even though you may think you can make the will and do whatever you want, it's very ironic. During your lifetime, you can do whatever you want, and it may be a smart or not so smart decision, and nobody can change that. But once we're gone, and it is our will, many people have an opinion whether we did the smart or the not so smart thing, and they can make it different. Section 60 WESA. WESA is the Wills, Estate, and Succession Act. Thank you so much for this. This is basically the paragraph in the legislation that says that any spouse or child who feels they have not been adequately provided for, they can contest your will. So spouse and children have a right to contest. No, unfortunately, I shouldn't say that. I shouldn't say unfortunate because it's letting you see what I think, but unfortunately, stepchildren do not have legal standing, which is why blended families, it's so very important to have very good advice and think this all through very, very well, because if you're in a blended family and you happen to die first, your subsequent spouse has no legal duty towards your children. Absolutely zero. It's treated common law, and married is exactly the same. There is no difference. Mm-hmm. Yep. Yep. Yep.
And say, well, I'm entitled to 50%.
A common law spouse has exactly the same rights than a married spouse. There's absolutely no difference. And spouses and children are basically by the law on equal footing.
Oh, good.
So if you die without a will and you have a spouse and children, they will inherit all at the same time. Not all goes to your spouse and then to the kids, no. But most people making a will, I shouldn't say most, but many people making a will, make a will and step away from that. Most people make a will and say, when I die, it first all goes to my spouse. And when my spouse is gone, it will go to my children. But if you die without a will and you have a spouse and children, they come in, they sit at the table at the same time.
Yes, I was concerned because the way my will is set up, I have a common law spouse, and so 25%, actually, and I have 3 children, so I've divided it.
You cannot know for sure that he will think that 25% is fair.
That's exactly what I'm worried about, even though.
Because if depending on the length of the relationship, but let's say also you become quite ill for a very, very long time. He takes care of you day and night. I mean, is just like an amazing, amazing, amazing person. He could say, excuse me,
Yeah. Okay, thank you.
it's complicated. Yeah, yeah, it's complicated, right? And I mean, these recent court cases show that, right? And that are just being publicized. And also cultural and how traditional things, how people have always done this and say, well, this is what we used to do and my kids will honor that. Once we're in the second and the third generation, you know, and remember, you, the person, you know, the mother of the family, you will be gone. So they don't have any hesitation now to pick fights, which they may not have done while you were still there. No, but it's true,
Thank you.
right?
Yeah,
It's
exactly.
true. It's
Even
true.
though he says, oh, no, that's fine with me now.
Yeah, everybody
he could turn
says
around.
that, but you know what I say to that?
Yeah.
This is like going to dinner and you say, can I bring something? And they go, no, don't bring anything. And then you don't bring anything, and then they go, can you imagine? Like, really, she had nothing. Like, no, like, it's exactly that. All right? So I could go on and on and on, but obviously this is not what it's going to be. So I will just not even delve into the cautionary tale. I hope this was...
No more questions. Let her talk.
No, I will just say on the cautionary tale, I'm not going to go into details, I'm just going to speak just generally, is that I think the cautionary tale is that most of us seem to have me included, right? I'm no different, right? We think of our journey as a straight line, right? And we kind of, and we hope it will be a straight line. And we have projected already certain things. Oh, I'm going to do that, and then I'm done. And then my grandson is going to graduate. And, you know, we have all these things. But the problem is that life is not like that. It's not a straight line. And so when we sit here and you take stock of what your life looks like today, and you base your decisions on that, by the time all these things will come to, you know, realization, it will be against a complete different backdrop. Your children will, in the meantime, be divorced, way better off, way worse off. You know, everything will have changed. Your money will have changed. Your perception will have changed, right? And that is where all the pitfalls are, is that people make decisions today thinking that life will always be this way. The other big thing, cautionary tale, would be around joint assets. Please, 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 be extremely, extremely, extremely cautious before you start pooling assets for whatever practical consideration you may have with other people, including your children. Because everybody says, no problem to be on the title, sure. To be on the bank account, sure. But you need, for whatever reason, to get them back off because they're in a bad relationship or they have debts that you didn't know of but you now learned about or whatever. You cannot unilaterally take them off, right? The other thing, pardon?
Are you including your spouse in that? Or?
Yes, yeah, definitely. Yeah, because your spouse is only as long your spouse as he or she wants to be your spouse. Yeah. The other.
Don't forget that.
I'm so sorry. The other thing I would say. Yes, sorry.
Just one question. How often should you reconsider redoing your will?
I mean, the general advice is every 7 years. 7. The idea being that we go through life cycles and that sort of every 7 to 10 years, we enter a different, you know, phase of our life, right? And so do the people we usually had in mind, like our children and so on, right? Yeah. It doesn't mean you need to change your will. It just needs to, it means you take it out of the drawer and have a look at it, right? Okay, other cautionary tale would be around validation, okay? Lots of people seem to think that all these fights about estates and family is about money. And I personally, professionally, do not fully agree with that. Most of what I see, it all stems from I have not been validated enough. So it's like a perceived lack of validation. It could be true or not, right? But validation is huge. I've thought about this all the time, for all this time that I do the job that I'm doing. And I've come to a little personal conclusion that this must be from the time that we were in school, you will appreciate as teachers, that ever since we're very little, validation is instilled in us. If you're gonna sit still, then we're gonna do something that you like to do. If you behave well at grandma's house, you'll get something, you get an extra dessert. So, and it's like this in life, you know, you do your first job, you get to stay, right? Probation, you get to stay, right? Then, anything pretty much you think about it, anything in life, we may not think about it, but we are conditioned that if you do something right, there is a little bit of a recognition that happens. When someone is not finding in the will what they thought they should be getting. And it's not necessarily about the money. It's about this niece gets 10% and I'm the other niece and I only get 1%. Why is she so special? Right? That's what it's all about, often. And then the money and the chase for money becomes, of course, the translation of that validation. But the underlying thing is the validation, which is why when you make decisions in your family life about helping one kid with a down payment or helping them pay off some debt because you think it's so horrible that they carry such a big, debt balance, just be mindful how your other kids think about that, how they feel about that, right? This all has very deep implications. And sooner or later, it's going to come to roost. And that's what we, the legal people, then get to deal with, right? I meet people and they are estranged from one of their children, or a child will tell me they're estranged from the parent. And in many cases, they can tell me they can even say what the moment was when it happened. But there's just as many cases where they will say to me, I have no idea. I don't know why my daughter is not talking to me for the past 10 years. I've got no clue. I don't know what I did wrong to her. And don't you think that is fascinating? I find that fascinating, in a way. So, and it happens to all of us. And this is another thing. We can never, ever think, well, what happened to that family, never going to happen to me. No. No, we should all, no, you can't think that way. It's not. Life is not like this, right? So I guess this is my closing to you, is just to, whatever you do moving forward, right? I go back to that protection. It's about protecting not just yourself and making sure you've got legal documents in place so you have an advocate for when things are not so great, but you want to definitely think about how is this impacting these people, how that interplay will pan out, what will they think, is this going to work, yes or no? And I thank you so very much for putting up with me.